Good afternoon. We are going to go ahead and get started with our program for our lunch period. For those I have not yet, my name is Jennifer Collins, and I am the Dean of SMU Dedman School of Law, and it is my absolute privilege to welcome you to this keynote address. I want to extend a very special welcome to all the attorneys from the community who are here with us today, our law students, our students from the Meadows School of the Arts and the Lyle School of Engineering, and a very special welcome to our high school students from Skyline High School. We hope that many of you will consider a career in law and that you will want to come do it at SMU. But we are really so delighted that you are here. If you have questions for us, please approach a professor during the break, and we would love to share whatever information we can. I want to extend my deepest thanks to our extraordinary faculty directors of the Ty Center, Keith Robinson and David Taylor, and our executive director, Natalie Greco, who worked tirelessly to put programs like this together. Can you join me in a round of applause for them? And also to our Thai scholars who go to law school full-time while also working really hard to support the work of the center, and we are so grateful for all of you. With that, I'm going to turn it over to Professor Taylor, who will introduce our very exciting keynote speaker. We are so grateful you are here.
All right, thank you, Dean Collins, and thanks again, everyone, for being here. Good afternoon. Let me, before I introduce our keynote speaker, let me use this as an opportunity to talk about our next event that you will want to come to. Our next major event is what we call our Innovation Lecture Series, and we're going to hold an innovation lecture on April 2nd. In the evening, we're going to welcome to the law school a man named Josh Malone. He's a local engineer, former engineer at Texas Instruments, actually, and he's an entrepreneur. He invented and patented the technology you may have seen that is used to fill literally hundreds of water balloons in mere seconds. And he's going to tell us our story. It's called Bunch of Balloons is the product that he sells. And you could call it a toy, but he has been fabulously successful. The revenue he is generating based on his patented invention and actually selling a product covered by his patent is in the millions of dollars. So while these devices are now sold at Target and Walmart, you may have seen even commercials or advertisements for them. You may also be seeing infringing knockoffs, unfortunately. And so on April 2nd, I will actually interview him here on campus so that we can hear his story, how he came up with his invention, how he secured financing through an incredibly successful Kickstarter campaign, how he sought and obtained patents on his technology, how he began manufacturing his device in China, and what will probably prove most interesting, how he fought a serial patent infringer in federal court and how he had to defend his patent repeatedly at the Patent Trial and Appeal Board, winning time and time again until he obtained literally over $30 million in judgments and settlements. So he'll use this as his experiences as an opportunity to comment on the state of the patent system in the United States. So if this sounds interesting, and I think hopefully I've described it in a way that it does sound interesting, sign up and register. We'll be advertising it. We'll have a registration link. It'll be on April 2nd in the evening. And so with that, let me now introduce our keynote speaker, Donald Passman. Don is the author of All You Need to Know About the Music Business, now in its 10th edition. He practices in Los Angeles with the firm of Gang, Tyre, Raymer, Brown, and Passman, and he has specialized in the music business for over 40 years. His clients have included Taylor Swift, Adele, Green Day, Pink, Elton John, Stevie Wonder, Paul Simon. That's just a short list of, I'm sure, many other famous clients. So he's actually lectured extensively on the music industry, including at Harvard Law School, Yale, USC, UCLA, and other law schools. And so we're happy to have him come to SMU. He's been listed in the best lawyers in America for over 20 years, as well as in the top 100 lawyers in California, the top 500 attorneys in America, Hollywood Reporter's top 100 entertainment attorneys, and it goes on and on. Billboard's top 100 music lawyers, etc. Turns out he's a Dallas native. He's a graduate of the University of Texas and Harvard Law School. And so I'm told what he's going to talk about today is how copyright supports creativity, how he got into entertainment law, and some substance that would prove interesting to you in the audience related to the Digital Millennium Copyright Act, and YouTube, for example. He may also tell some childhood stories, perhaps. I don't know about, he mentioned something about this Texas State Fair and the Farmers Branch Water Tower. I don't know if he'll mention those, but he grew up. He's a local guy. So I also, though, want to recognize his stepmother is here, Jean Passman, who I understand turns the young age of 96 next month. And so if we could all... So with that rather long set of announcements and introductions, let's go ahead and welcome our keynote speaker, Don Passman.
All right, thank you, David. And I also want to thank Natalie Greco for all of your work in setting this up. I appreciate it. So as David said, I want to talk first about how I got into music, law, and entertainment. I want to talk about how copyright sustains creativity. And lastly, I'll talk about some of the challenges of new technology, trying to keep up with what's actually happening in the industry. So it does feel wonderful to be back here. I did grow up in Dallas, not far from Love Field. And every Friday I would drive up Mockingbird to my grandmother's house right past SMU. So there's a great deal of resonance to be here. And my coming back proves that I will go over 1,500 miles to hear myself speak. So the personal part of it I will not keep as long because as riveting as it is to me, it may not be to you. But in the third grade, when other kids wanted to be firemen and policemen, I wanted to be a lawyer because my dad was a lawyer here in Dallas. In fact, there's still a firm with his name on it here. And I always loved music. I played accordion when I was a kid. It was arguably a cool instrument then, arguably not. And I went on to play guitar and played in bands when I was in college called Oedipus and the Mothers. And I had a band in law school called the Rhythm Method. At any rate, my stepfather was a disc jockey here in Dallas on KLIF, which back then was a top 40 station. He got a job in Los Angeles at the top 40 station there, which is when he and my mom got married and moved to LA, so I had not much choice about it at that point. But I did end up coming back to the University of Texas before going to Harvard Law School. And when I got to law school, I was planning on being a tax lawyer based on a casual comment that my dad said about, if you're a tax lawyer, you can practice anywhere in the country. But it turned out I really liked tax. It was like solving these very intricate puzzles and trying to get the pieces to fit together. And then there were no clerkships after the first year in those days, but there were between second and third year. And I looked at them, and one of the firms at entertainment law. And I thought, oh, that sounds like everything wrapped together. Because my dad was my stepfather was a disc jockey, so I was around the music business growing up. I loved music, always listened to music, and it felt like this could be a way to combine everything I wanted. So I looked at a firm in Los Angeles, which was the top tax firm at the time, but they said, we want to go into entertainment law, and you will, if you come here, you can be on the ground floor, you can build things up, and be part of that growth. It sounded fabulous until I got there when they put me in corporate securities, mergers, and acquisitions. It was possibly the worst year of my life, except I did meet my wife there, so I can't completely complain. I took a class at USC on the music business taught by a couple of music lawyers. And I thought, this is like fun. This is like not working. It's exciting. It's everything I wanted to put together. I'm wasting my time. So I ended up changing firms. I went to a firm that at the time was doing all not corporate, but company work. We were representing major record companies, major publishing companies. And my heart was always on the artist side of things. But the firm was doing that, and I was just happy to get in the business. It was fabulous training, because when you're on the company side, you're writing contracts and drafting, and you're dealing with every talent lawyer in town, so you understand what they're asking for. So it was a fabulous education. It just wasn't particularly where my heart was. I ended up later teaching the same class at USC that I taught. And in the course of teaching the class after a few years, I realized my class notes were an outline for a book. And I always wanted to write a book. I started doing creative writing, literally dictating a novel to my grandmother when I was 6 years old. Wasn't very good, but it's something I always had an itch for, and I didn't have time when I was practicing law. I was working really hard. But this sought a way to put it all together. So literally started dictating it, put together the book, and that was the first edition of my book, All You Need to Know About the Music Business. Since then, I've continued to do it, but I wanted to build an artist practice. In the rearview mirror, that looks brilliant because all of the company work went in-house. It used to be that their in-house capabilities, when I started, was very limited, so we would get all of the major deals. So I learned all of the very top level aspects of it, but that went away. So I intentionally went out and started building up the music side of it. So let me talk for a minute about what I really like about practicing law in the entertainment area. And it's because of the conflict between creativity and business. And that's been there for a very long time, as I'll tell you in a second. But if there's no creativity, there's no business, there's no product. If there's no business, if the business people can't make a product, then the creative people can't make a living. So they have to coexist. But there's continuous conflict because creative people want whatever it takes without regard to money, most of them, not all of them. And business people need to make a profit and want to obviously watch their costs and keep things as in line as they can. And so now to move to a complete non sequitur, but not really, how many people have heard of a painting called The Night Watch? It's in the Rijksmuseum in Amsterdam. It's one of the most famous paintings in the world. It's about the size of this stage, maybe bigger. And it was commissioned, it's by Rembrandt, and it was commissioned to paint this group of army people. And in those days, the way artists made a living was you got commissions because that was it. And if people liked you and they hired you to do paintings for them, you made a living. And if they didn't like you and you didn't do it, you didn't. So all these people chipped in and paid Rembrandt to paint their painting, and then when it came out, it was some of the people in the foreground, some of the people in the background, some of the people in shadow, some looking sideways. And what they had wanted was a bunch of people standing there equally, all facing forward, which was the style of the day. And they were not happy, to say the least. Indeed, it arguably cost him his career after that. So I show that as an example of how far back, this was in the 1600s, the conflict is between art and business. Because the business people, they wanted pictures of themselves stiff and facing forward. Rembrandt wanted to create something that was spectacular, and the conflict has existed ever since. What I like is being right at the center of the controversy and trying to speak both languages. Because I come from a creative background, I understand creative people, and because I understand business, I understand the business people. And particularly, even given that I started on the record company side of things, I really understand what their needs are. And I like being the translator in between the two. Creative people, you can't talk to creative people in the way you talk to business people. They have to understand, first of all, it has to be very simple. Secondly, not all of them, some of them are really sophisticated in business, but for the most part, they're not interested in business, which is, of course, why they're in creative arts and not in business, is they don't have any interest in it. And there is an art to persuading an artist to do something that is in their best interest that they don't particularly want to do. And that's not solely my job. They have a personal manager who's in the equation, and that's an essential part of it because you have to catch them at the right time, in the right mood. You have to be able to read that. You have to be able to get them to understand it, and a lot of times get them to think it's their idea, which you can do by planting seeds, and then suddenly it's, oh, brilliant. Why didn't I think of that? All right, enough about me. So let's talk about copyright. And the theme that David asked me to talk about is how does copyright support creativity? And so just as you're anticipating, I'm going to talk about France in 1789. Now, what happened in France in 1789? Nobody sleeps, come on. The revolution, right. Okay, they overthrew the monarchy, they cut off Louis and Marie Antoinette's heads, and along with cutting off their heads, this is not well known, they also revoked the copyright law. And what happened when they revoked the copyright law? Well, immediately everybody copied all the popular works and threw them out in the marketplace. And 20% of the publishers went broke almost right away. The others survived. The only thing they could make money on was to publish gossip, which was current, and to publish news that would be distributed before somebody else could copy it. Otherwise, they couldn't do it. And there was no profit in anyone creating a literary work because they couldn't make any money on it. As soon as anybody saw it was successful, everybody would copy it, and they wouldn't get paid for it. And nobody's going to particularly pay them for it when everybody could copy it. So there was this complete stifling of creativity during the period. And people wouldn't be able to go into the arts because they can't make a living. Again, back to our equation. You can't have an artist living unless there's business, and you can't have a business unless there's artists who are creating, right? Actually, I'm going to diverge for 1 second and tell you a funny story. There was a guy that ran EMI at the time, one of the major record labels, who came from the food business, from General Foods. And I said to him, what do you think is the biggest difference between the food business and the music business? And he thinks for a second and he said, well, in the food business, the product doesn't have an opinion. He said, if you want to change a ketchup bottle's shape, it doesn't argue with you. You want to change an artist's album cover, you're being in for a long fight. So the idea was that, at any rate, back to this. So the principle is that people wouldn't go into art unless they could make a living from it, right? But there's even a more subtle issue than that. If you can't control your work because there's no copyright, right? How would you like your song to be used in a movie with a scene of people shooting up drugs or a very violent scene? How would you like your song as a campaign rally for a politician you hate? By the way, I've had that call a number of times. How would you like it to be the theme for the North Korean Tourist Bureau? The idea is that there is some kind of control that artists would want, not just because of the money, although that's obviously important because they can't live without it, but also for the whole purpose of their art and who they are and what they stand for. And if everybody can appropriate someone's copyright without permission and without paying for it, it also taints the whole system. And unless we go back to the Medicis, we were people that would just, were very wealthy to pay money to have artists create. We can't have a business unless we have a copyright, unless we have the ability to do it. And what happened in France in 1789? 3 years later, they put the copyright law back. They found exactly the same thing. It didn't work. So, I have issues, and in fact debate with friends of mine who were on the other side about whether or not there should be no copyright, whether or not everything should be free and everybody should have access to it. And it's not that I don't understand where they're coming from, but living the business, there are consequences way beyond that that they don't necessarily think about. Okay, back to the 21st century. So, at its peak in 1999, the recorded music industry was about $15.5 billion in the United States. It dropped just like France because of piracy. When Napster came along, when people could share files, nobody had a need to buy things. And the record companies were stubborn about it at the time, for a reason I'll get into in a second, because it's very similar to what's happening in the movie industry right now. The record industry at the time was making a lot of money on CDs, even though people only wanted 1 or 2 songs. And so when along came these free file sharing services, people began to take what they wanted, which was the song they wanted off the CD, and not have to pay $16 for it, right? And so the record company didn't adapt it right away. They took a stand of that cheapens our music, we can't do that, we have to hold the line. It's almost laughable. It's like some guy standing at the front of his store with a shotgun saying, you can't have my music, while all the product's going out the back door. Because people were stealing it because they wanted it. And it was cheap, and they were angry about how they'd been treated. But there's a reason that they did that that's beyond what you might think. The reason that they did it was partly out of self-protection, but it was mostly out of the idea that the music retailers were very powerful. When piracy started, the music retailers were 97% of the business. In other words, you go to a record store and you buy CDs. That was a big part of the business. That gave these people a lot of clout. So if they were saying you're not going to get shelf space if you start selling your music digitally, we're not going to carry your product, we're going to muscle you. Is there a 2 or 3% of the business I can pick up for downloads, which was the only technology at the time, and versus 97% of my business. So they were in a serious dilemma, exactly the same dilemma that's going on today in the motion picture industry. The theaters are very powerful, but at the moment, box office is about 25% of the movie business and dropping. And yet the people who show the movies are holding out and saying, no, you can't release it at the same time on digital. And Netflix, which puts out movies in theaters, only has a few theaters that'll do it. Most of them won't touch it because they're protesting. They know Netflix is going to put them out of business. Same thing that's going on now was what was happening in the music business back then. So they were taking care of their core business, but meanwhile their core business was disappearing and dying because of the piracy. Because you can't compete with free. It doesn't matter how low you drop your price if your competitors are giving it away for free, right? You can't stay in business, you can't make a profit. So we went through this period where it dropped heavily, and it dropped down to under 50% of what it was. And that stayed that way for 16 years, from 1999 until the first up year, which was 2016. And it had been either declining or that. But since then, it's gone into double-digit growth. And the reason for that is streaming, of course. Streaming is suddenly becoming the major way to deliver music. But even with all that, it's still under 60% of what it was at its peak back in 1999. So the business, though, is 80% streaming today. There were just figures released by the Recording Industry Association that showed that. And what do you think is the second thing to streaming? Sorry? Vinyl's a good guess. No, I'm talking about recorded music, but yes. Well, let me put it a different way. What do you think is bigger, physical or downloads? Downloads is what I would guess too, but it turns out it's physical. Interesting. Physical is about 10% and 8% downloads. The reason I think, this is my speculation, is that the people who buy CDs aren't so technologically savvy, so they're still buying CDs. And they don't realize that, there's another way to do it. So either that or they're collectors or however you want to do it. Vinyl is growing massively, but it's under 2% of the business. It's only slowed by the fact that every pressing plant in the world is working 24-hour shifts. But it's still a minuscule part of the business, and it's really more like merchandise. It's really, what am I doing wrong? Speak up. Is that better? Okay, sorry. So it's really more like merchandise. Vinyl is interestingly a new technology to kids who didn't understand it used to be an old technology. Streaming is a way more profound change in the music business than you would think it is just by looking at it. And let me unpack that a bit. Since the beginning of the music business, music has always been monetized by selling something. It was a piano roll. It was a wax cylinder. It was something. And it didn't matter if someone bought a CD, whether they listened to it once or they listened to it 100 times, the artist got the same amount of money. In fact, if you never even unwrapped it, the artist got the same amount of money from the sale. Now, that's also, when you went to a record store in those days, you could buy a number of CDs at the same time. But you can only listen to one song at a time, right? And that's a change that I'll talk more about in a minute. It has more implications than it sounds like, but I'll explain that in a second. The other big change is this one. In the past, if I went into a record store and I had if I put out a big record, the number of records that I sell is dependent only on my fans who want to come out and buy it. It has nothing to do with your fans and your record. Today, in a streaming world, that's not true. If somebody is listening to my song, they're not listening to yours. Okay? In fact, in the old days, a big seller would bring people to stores. They'd be more likely to buy somebody else's CDs while they were there. Now, you can only listen to one at a time, and somebody listening to me is not listening to you. And let me explain why that's important. It's important because the way streaming is monetized works like this. The streaming service collects money basically from two sources, unless they're subscription only like Apple Music, but if you're Spotify, they get money from subscribers and they get money from advertising because they have a free tier where you can listen to ads and you can do it, or if you're YouTube, it's only from advertising, right? So they collect money every month. They put all this money in a pot. Then they look at, all right, how many plays did we have this month? I'm just going to use some simple numbers for a minute just to illustrate the math, okay? So let's say $100,000 gets collected. It's obviously multi-millions, billions in fact. But let's say $100,000 is collected in a month. And there's 100,000 plays. And I have 20,000 plays, okay? I'm going to get 20% of the money. That's how they divide it. They look at how many plays, what percentage do you have, and then they look at the money, and then they divide it based on the percentage, okay? So that means, which it takes a minute to sink in, that means there's a finite pool of money every month. That means that unlike the days when you could have a massive seller and that month might spike up to X dollars in sales across the industry, this month there is X amount of money and it doesn't matter that 80% of it went to one artist because they did it. The money has nothing to do with the listening. It has to do with how many subscribers and how many advertisers there are. So it's completely unrelated to the sales. The only thing the sales, to the listens, the popularity. The only thing the popularity means is what percent of that pie do I get? So that also means, for the first time in history, that every time I get a listen, you don't get one, I get more money and you don't. We have a zero-sum game. Never existed before in the industry, okay? So to the extent that there's a certain amount of money, the play now is how much of that pie do I get? And how does it work? So the competition in a streaming world is now for ears, not for sales, not for anything else. And therefore the marketing is completely changed. It's changed as to how they do it, and it's gotten very sophisticated. Playlists on streaming services, everybody familiar with those? Where you create your own, or they create one for you, have become radio in the new ecosystem. I'll talk about radio in a second because there's a real question about its future. But now playlists are doing it, where you're placed on the front page of the service, the streaming service. There's a difference they call between lean in and lean back. And what does that mean? Lean in is where you're actively looking for something to look at. Lean back is where you've already sort of picked a playlist and you just lean back and let somebody play it for you. And the goal is to get on people's playlists, their own personal playlists, so that your song is continuing to be streamed, even if they're just putting it on in the background, because again, the more streams you get, the better. So it's a completely different marketing game. Now, let me talk about radio. Radio historically was the most important factor in selling music. Not true anymore. And now it's an important factor to drive streaming. Interesting. Radio's advertising metrics are based on 16 to 24-year-olds. They're not in the music business, they're in the advertising business, right? So they're going to be looking for programming that will bring that in, and it's a relatively narrow amount of programming. The streaming services are much broader. I mean, there's people that are preteens and there's people that are, in their 80s listening to streaming. So you can have a completely different set of things. But on the preteen part, what's interesting, which we'll know in the next few years, is when those kids grow up, are they going to go to radio when they hit 16? Maybe not. Probably even not. The music industry, by the way, has no particular incentive to drive people to radio, because under a quirk in the copyright law, thanks to the radio station's enormous clouded legislature, no money gets paid to the record company or the artist when music's played on the radio. The songwriter gets paid, but not the record company or the artist. And yet on streaming services, the record company and the artist are paid a lot. So their incentive is, let's go to streaming. Let's move over there. That's where we want you to listen. That's what we want you to do. And they see radio as a way of moving streaming. But radio, as I say, has become a narrower channel, and it's only for certain kinds of artists that do it. So very big shift in the whole system. Let me talk for a minute about a controversy that's going on. It's not a huge controversy because nobody's really moving to do it, but it's a fairly interesting one. And that is whether or not the way that the money is divided up based on the number of plays is fair. Now, it sounds fair on the surface of it, but if you drill down a level, try this. The question is it fair to the smaller artists? Is it fair to the niche artists? And the answer is probably not. But let me explain. Let's suppose there's a streaming service and there are only 2 subscribers, you and me, and there are only 2 artists on the whole streaming service, Fred and Lisa, okay? I listen only to Fred, you listen only to Lisa, right? We each pay $10 a month, there's $20 in the pool. Now, let's say I listen to Fred 10 times that month, but you listen to Lisa 90 times that month, right? Lisa's going to get 90% of our $20 or 18 bucks. I'm way oversimplifying, but just to make the point. And Fred's going to get the other $2 because it's only 10%. Now, let's suppose we did it differently. Let's suppose that the system, instead of based on the number of plays, is based on the number of users. In other words, that my $10 is going to be allocated only to the people I listen to, and your $10 is only to the people you listen to. So in that sense, under the same equation, my $10 would all go to Fred, even though I played only 10% as much as Lisa, and the same to Lisa. Is that more fair to the niche artists, that the people who are their cult fans and listening only to them get more of it? I think so. On the other hand, politically, it's very difficult. First of all, it's enormously expensive for the streaming services to move over to that kind of a model. It would take completely reworking their systems. It would cost a lot of money. Secondly, that money is going to come from the top earners. And we don't know how much that means. The only statistic I've seen on it was an article about a study in Finland, which is obviously not representative, more than you would think, because the Scandinavian countries, because that's where Spotify started, are much more, have adopted streaming, almost to saturation, like 90% of the market. And the study there, they thought would be about a 3% swing toward the middle class and the cult artists. So the problem, of course, is who's going to advocate for the middle class and the cult artists against the major artists. So it's an interesting issue. It's poking around. It's not got much wind behind it, other than people think that it's fair, or at least I think it's fair. And so that's poking around. All right. So let's talk for a minute about who do you think streams the most music of all the services? YouTube. Very good. YouTube streams more than all the other services put together, including the pirates. Okay? Who do you think pays the least of all the services? YouTube. Now, the reason YouTube pays the least is because they're completely advertiser supported, and because of the funky way that they compute how the advertising money gets allocated, because they are in the advertising business primarily. Now, why does anybody let them get away with this? All right, I'm going to, because most of you are lawyers, but I'm going to keep this simple enough for the non-lawyers to follow, because I've had people do that to me, and I swore I'd never do it to anybody else. So I will keep this simple. But it's the reason that YouTube gets away with this is because there is a loophole in what's called the Digital Millennium Copyright Act. And YouTube has slid into this loophole in a way that has really made them possibly the biggest problem in the industry, because they are the only service that's on mobile devices that allows true interactivity for advertising. Spotify does it, but not on mobile devices, and most of the listening is on mobile devices now. Spotify will let you do it on your desktop for free, but not on your phone, okay? So YouTube is the only one that does that, and basically they're giving the music away for free when the other services are trying to charge for it. So why? Okay, the Digital Millennium Copyright Act has an exception in it for certain things, and the key here to understand with YouTube is that it is, unlike Spotify, where Spotify has a server, copies all the music and has it available, all the YouTube music is posted by users, okay? The Digital Millennium Copyright Act says if I find out that there's an infringing song on it, then I have to give them notice before they take it down. That comes out of something we used to call a newsstand exception, meaning the following. If a little guy selling, on the corner with a newsstand selling magazines and newspapers, there's a Time magazine article that has an infringement in it, right? A copyright infringement in the article. The guy, technically, if you are distributing a copyright infringing article, you are liable for copyright infringement, right? But the guy at the newsstand is this little schlepper who has no idea what's in his magazines, and so nobody's going to go after them for distributing something like that. Well, the same idea came up in the DMCA. They said, wait a minute, we're YouTube, we have billions of posts on our site, we can't police all that, we got to be treated like a newsstand, essentially. And the only way we're going to be responsible is if you come and tell us that we're copyright infringing. Then we'll take it down. That sounded just fine in the days that the Digital Millennium Copyright Act was passed in the 90s. It doesn't sound so fine today, and it didn't work in practice, because what happened was this. They would put up a bunch of infringing songs. They would just take songs that were not authorized to be put up there. The record labels would send them 1,000 notices. They would take them down. The next day, other users put them back up. Remember, it's the users on YouTube. Very different from Spotify, very different from Apple Music, where it's put up by the company. Different set of copyright laws. They would take then another set of notices, they would take them down, another set of users, and it just became this whack-a-mole game that the companies couldn't win. So YouTube, under this guise, finally comes in and says, you can keep doing this, and you can keep sending the notices, and we'll keep taking them down and letting other people post them, or we'll just make a deal with you, and you take what we give you and grumble away, which is basically what happened. So the companies now license them. The percentage terms of YouTube are exactly the same as everybody else, but the other companies aren't allowed, they're very restricted in what they can do with their advertising supported. YouTube is not, because of this whole loophole in the industry. That's why they're getting away with putting it up on a free basis on the mobile phones, which again is taking a big chunk out of it, both because the revenue is less and because they are such a big distributor of music. So, can we change the law? But way back in the beginning with Napster and with CDs being copied at home, the villains in the industry, people always talked like it was the little kid in Pennsylvania who figured out how to copy a CD or burn a new CD on it. No, the real villains were always the computer industry and the tech industry. And why do I say that? Because they knew full well what their CD burners were being used for and their blank CD sales were being used for, and they didn't care. YouTube knows perfectly well that there's a lot of infringing material going through their pipes, which they could technologically block if they wanted to, but they don't, because they're getting paid and they don't have to. And they're just letting it go through because it's to their advantage. And who do you think has far more lobbying clout in Washington? The music industry or the tech industry that makes more in a day than the music industry makes in a year? They're far more lawyered up, they're far more influential, they have a lot deeper pockets, and it's not much of a contest. The only hope on the horizon I've seen so far is in the European Commission, there's a move to narrow the safe harbor. What the music industry would like is what we call a takedown, stay down, which means once you get a notice that this is infringing, you take it down and you leave it down. You don't put it back up, and you filter out other people from putting it back up. And it looks like the European Commission adopted rules saying, but the European Commission only directs its members to do something. And they have, I think, a couple of years to do it, where they've said they're going to narrow the safe harbor. This is called a safe harbor provision, meaning that, if you once you get the notice, this whole system, they're going to narrow that in the European Union, which effectively would bring you to the table, because they can't geo-filter things for just that territory as well as they would like to, and basically they'll have to come and make a deal. But that's still a few years off. Brexit completely screwed up the ability to get that through in any kind of system. It's not the law in the UK, and not their priority at the moment. So we're in a period where it's not clear what's going to happen. Hopefully we're going to get some help. Hopefully it's going to be better. At the moment, though, it's still one of the biggest problems we have in the industry. Okay, back to the big picture. Music is not going away, certainly. It's as popular, in fact, arguably, probably more popular now than ever. More people consuming it. It's still one of the cheapest forms of permanent entertainment you can get. In the heyday of the music business, the statistics I've seen were that the average music fan was buying $40 to $45 of CDs every year, somewhere in that range. Okay, at a subscription service, people are nominally paying $10 a month, but the average is actually $7 a month. And the reason that has to do with student discounts, family discounts. It comes out to about $7 per consumer per month. Well, that's obviously $84 a year, double or almost double what people were spending on CDs in the heyday. So the potential basket of money is much, much bigger. Secondly, the people that are spending it are people who would not go to a record store. When record stores existed, consumers, when they got to their early 20s, basically stopped buying music. You know, they might listen to it here and there, but they really wouldn't go to a store, and they didn't follow it and lost interest in it. There's an interesting, by the way, psychological study that I don't know enough details to really quote, which never stopped me. But basically, that there's a theory that by your early 20s, the music's already imprinted on your mind as to what you like and so forth, and there's not, for most people, there's not the same change or passion for it as they get older. I don't know if it's true or not, but it clearly was true that people stopped buying music in their early 20s in those days. But now we've got little kids and we've got old people who want to listen to Lawrence Welk, and we've got all kinds of consumers that would never go to a record store. So in my opinion, the music business is going to be bigger than it's ever been. On the other hand, interestingly, in the countries where it's already been for a while, like Scandinavia, it's starting to slow down in growth or stabilize. And the reason is at some point we're going to hit saturation, meaning as many people who are going to subscribe, that's going to be it. And then the only way to change the industry is to raise the subscription price. But it's the growth just by acquiring new people and getting them into the ecosystem is not going to happen at the same pace that it has before. But even given all of that, I think there's no way the industry won't be bigger than it's ever been. And I think that those of you coming into it, you know, are going to have a different perspective and an energy and a chance for innovation that those of us entrenched in it probably don't have, just because we're entrenched in it. And most of the innovations tend to come from people getting new into the industry. So I will stop there with the information portion. I'd be happy to take a few questions. Yes?
Those of us in the publishing industry have been very concerned about the way in which the idea of transformative use has been very aggressively used in fair use law. It has gotten to the point where the Association of Research Libraries makes the argument that novels were written for the general public and not for use in student classes. Therefore, they are being repurposed for use in student courses, and therefore libraries should be able to reproduce all novels without permission from the publishers. I'm asking if any such thing has happened in the world of music, where, of course, transformative use started getting momentum from the parody of Two Live Crew of Pretty Woman. That's the Supreme Court case of how it all started.
Right. Okay, let me rephrase the question and also try to make it intelligible to the non-lawyers. There's a concept in the copyright law that if you do something that's called a fair use of a copyright, you're entitled to do it without the permission of the owner and without paying the owner, because you've made you're allowed to do it. An easy example would be a newspaper publishes a copyrighted photo of someone who passed away recently or is involved in a news story. Those are the common types of exception. There's a whole section of the copyright law about where fair use is. A few of them are enumerated, like course materials and things like that, you know, for a small part of a work anyway. But more and more, it's becoming an issue in copyright infringement cases because people are claiming that a fair use is way broader than most people would have thought. And one of the key tests in fair use is whether or not something is transformative, meaning does it take the original work and use it in a completely different kind of work in a novel way that somehow makes it a different work, and that becomes fair use. There's a division in the circuits about this. Circuits meaning different parts of the country, and all copyright cases are in federal court. But there is a division between the different parts of the country over this. Some parts of the country say transformative means it's a fair use and you don't have to pay, and other parts say transformative is basically a derivative work, which is a technical term that means you do need copyright protection on it. So yes, we see that in every copyright case. Somebody's going to argue fair use and argue it's transformative. It's not a bright line test. Nobody really knows. But yes, we see it more and more and all the time, and in fact, on the other side, we use it more and more all the time. Yes?
I teach copyright, and one of the biggest challenges there is always trying to walk my students through the complicated world of music licensing. I wondered if you could speak a little bit about the impact you think the new Music Monetization Act might have for artists. Is this blanket license and some of the other steps like financing, do you think those will end up resonating at the arts level?
All right, the question is, there's a relatively new piece of legislation called the Music Modernization Act, and is that going to affect artists? And let me just explain what it is first. The Music Modernization Act came out of a frustration in the industry where the digital service providers literally couldn't find the publishers, who are the people that own songs, not the masters. Two different sets of rights in the music industry. Over here, masters recorded product. Over here, songs, completely independent, could be written by somebody else other than the artist. Completely different set of rights, okay? We're talking now about the song side. And the digital service providers, the Spotify's, Apple Music, were not able to literally find the owners of the songs in some cases, and were getting sued for copyright infringement and not having licenses. Sometimes they just threw up their hands and didn't do it. And as a result of this, the industry came together and created a system that's basically a required license, a compulsory license, that says that as long as you pay into this organization, if you're a digital service provider, you're not sued for copyright infringement, and then the organization, which is funded by the digital service providers, pays all of its income out to the creators, or there's a system, if the creators don't show up, to pay that extra money out to the people who do show up. So that's basically what it's about. Her question was, is that going to trickle down to the artist level? The answer is yes, I think so. I don't know how significantly it's going to move the needle. For the major artists and the major publisher, it's not as big a deal because they knew where to find them. It does take away the right to sue for copyright infringement, so therefore the smaller publishers may be prejudiced a bit by it, but overall I think it's a fair compromise, and I think it will be good for the industry. Yeah?
When looking at the new music climate, a lot of what people are aiming or wanting to build infrastructure more around independence. Are there any key points or anything to take into consideration when wanting to go with the independent route versus partnering or even signing to a record label? And then I also had, and then the second question, I don't know if I should wait for it, was this going to be...
Only because I might forget it.
Then I can wait.
Okay. By independent, do you mean do it yourself, or do you mean signing an independent label?
Independent and doing it yourself.
Okay. Do it yourself is, the industry historically had major barriers to entry. It was really expensive to manufacture and ship records, get them into stores. Even if you could do that, get the stores to pay you and to take it seriously, place it where consumers would see it. Also, radio was impenetrable unless you had a lot of clout. So the major labels had these serious keys to the kingdom. You had to go through them if you wanted to get any of those things. That all disappeared now because everybody can distribute their music. For I think it's $60 a year, you can put your music on TuneCore and be on every streaming service. The problem is everybody can do that, and there's tens or hundreds of millions of pieces of product out there that everybody's doing it with. So the question becomes, how do you break through the noise? And the way it's working now mostly is artists are starting it on their own. They're getting sophisticated about social media, about building fan bases, about building a relationship with fans, getting a buzz, getting something on SoundCloud that people are listening to. And once they do that, then they can either continue to do it, and if they're a niche artist with a relatively small potential for an audience, they're probably better off doing it because you're going to make more money per transaction. If you want to be a worldwide major superstar, you probably need a label's money, clout, marketing expertise, data, relationships with the streaming services to get your music heard over the noise. Your second question?
The other one was going to have to do with the songwriting side of publishing. I saw something to where the person was saying that if you're looking at 30 to 40% of the business having to do with synchro licensing, then actually start an independent, or start your own publishing company and then sign to the publishing company that you just created, versus just going with PR just as a songwriter. What are your thoughts on that? Should you start a publishing company if you're looking to publish your own songs for singing, or would it just go as a writer and shop the songs?
Well, starting a publishing, you can be your own writer-publisher without a publishing company. You can just do the licensing yourself. Whether starting a publishing company is more of a decision just on a business level, if you want a different name for it, or you want a different bank account, or you want to keep it separate in some way. So I don't think there's any particular need to do it. The issue is, how do you get your song out to the most? All right. So did you want to stop at one? Or one or one more question? Yep.
In practice, what's the difference between representing artists individually and representing the recording companies? I don't think they have the same facility. What's the difference?
They definitely don't have the same interest. I don't represent any of the major record companies for exactly that reason. I don't want the conflict of interest. I made a decision to be almost exclusively on the artist side. I do represent some smaller labels, but if I do, I don't have anything to do with their artists, and I, again, don't want the conflict of interest, because the interests are not the same, and I need to pick one side or the other. All right, well, thank you for inviting me here today.